look at them like there's no issue. They have serious problem. You don't know that man, that tall black man. What's that his name again? You begin to call them. Do you understand? That's how. So as a mediator, you are not to do anything like that. Confidentiality. But when it comes to court cases, before you know it, the news media they will help you to help you to spread it. Channel television, AIT, Al Jazeera, CNN, all of them will begin to spread it for you. Do you understand? That's court cases for you. So in the public domain, everywhere, litigation, that is in the public domain. But ADR are private. If it doesn't matter the case, it remains and dies with the mediator. You cannot hear it anywhere. You may hear it as example or a case study, but you don't know who are the people. They may decide to use fictitious names. If at all they want to mention them, they will use names that are not true. Fictional names. Do you understand? Preservation of relationships. Another benefit of ADR is that it preserves relationship. It saves relationships. But court cases create enemies. Once the court case is over, an enmity is defined. Enmity is defined. Do you understand? Court cases don't favor both parties. One win and one loser. One winner, one loser. So it's enmity already automatically. Once the court pronouncement is made, enmity starts. But in ADR, the parties themselves try to solve their own problem. So they contribute to whatever the outcome of the discussion, in the process preserving their own relationship. We can resolve our disagreement and still remain friends. Do you understand? But once you take the court the case to the court and say, oh, so it has comes to the level that you have to take me to court. No. Me and you, our path will never ever cross again. Do you understand? That's what it means. So flexibility is another benefit of ADR. Parties can tailor the ADR process to suit their needs, unlike the more rigid court system. Court is based on sometimes they talk about technicalities, they talk about so many other things. What the constitution say, what the law say, what the proceedings say, what case study between this one and this one, bring it back, and then they apply it based on this judgment, all this one. Do you understand? So it's very rigid. But when it comes to ATR, is more flexible. You can adjust position, you can compromise here and there, just to make sure that the outcome benefits everybody, mutual benefits in the outcomes. All right. So when to use ADR? When do you use ADR? When do you use ADR? Who can share with us when to use ADR? Right? When would you use ADR? Okay, ADR is suitable for various types of disputes, all right, including commercial disputes. You have business relationship that is not working well, or business engagement that did not go well. You can use ADR. If you notice, many banks now are using ADR instead of going to court, because going to court, lawyers will charge them, judges will charge them. Like, do you understand? Because they are banks now, so they have money, come and pay. Do you understand? So they charge them. So if you see, many of the banks are deploying the instrumentality of ADR now to resolve their disputes, commercial disputes. You traded a business with somebody and it didn't go ahead. How do you go? Do you go to court? No. Use this ADR tool to resolve the conflict. It benefits you more. Marital problems, family problems. You understand? Marital problems, family issues, family inheritance crisis. Use ADR tools to resolve the conflict instead of going to court. Why are you going to court? You are still friends, you are still family, you are still brothers, you are still a family. Why do you go to court? Going to court means total destruction of the family. You go to court after you win the case, forget it. You can never unite that family. Do you understand? So why should you do that? You have a family matter, you deploy the instrumentality of ATR and settle your family issues instead of going to court. Except on extreme cases that maybe the effort to use ADR to face that maybe you can try to try the court. There's a place. Litigation is still in perspective, but do all you can to deploy ADR processes to solve the problem. And then labor. You work, somebody did not pay you your salary, so you go to court. No, engage other ADR. They can go and talk, and then get your money back. Do you understand? Sometimes people go to human rights radio, television, like the MBRN. Do you understand? Brekete family. Sometimes Brekete family may not go to court. They will just go and intervene and then get you whatever you want without going to court. You understand? They come into it and they intervene and then get to it. If you want us to also intervene in such situation, you have a situation like that, you want the Institute of Global Peace and Conflict Management to help you, we can also help you to intervene. Do you understand? Although in most cases, sometimes we use lawyers, but it's not necessary. You understand? Just to intervene and then you get your result. You understand? So labor matters can also, you can use ADR. And then also community issues. You are in the community, you are one people. Why should you take a community issue to court? Even if clan against clan, there's no need to go into court. One clan is fighting another clan, there's no need to go to court. What you need to do is just to find a common ground where you can discuss. And if possible, you can bring a third party, maybe a third clan, to come in to intervene. Do you understand? If yourself, but even the intervention is just to facilitate. Or you can invite some government officials, they will come in, and maybe it's over a piece of land, and then they facilitate. And then there will be a resolution instead of going to court. It causes conflict, even destructive conflict. Sometimes court judgment come with, attending consequences like war, armed conflict, because maybe the court judgment did not go well with someone else, and then he decided to say, okay, since the court decided to rule like this, we will rule it our own way. Carry arms, begin to destroy virtually everything because of what court case. This is what we're talking about. It has an attendant consequences. Are we together? So when do you use ADR? Commercial, family disputes, labor matters, and community issues. Community issue may be over resources, resource control. You can still use ADR. Do you understand? And what are the benefits of ADR? I mentioned them: cost, time saving, confidentiality, preservation of relationship, flexibility. Are we together? All right. So if we're together, let's proceed. We still have a lot to cover. So that's unit 1, part 1. We are going to part 2. So we're going to compare and contrast, right? Comparison of litigation and ADR. Right? So in what ways are you going to compare these two? First, we look at the process. The process of initiating ADR or litigation, they differ. Do you understand? Process. Number 1 is process. You can compare them based on the processes of initiation. All right? So litigation is a formal legal process governed by court rules and procedures. Right? It involves filing a lawsuit, discovery, trial, and potentially an appeal. Right? Sometimes maybe a lower court judgment may not be okay with you. You appeal to the appeal court. From appeal court, you go to Supreme Court. I think we do have people behave like that, most especially our politicians. Once a case is not well with them, they must drag it to the point of Supreme Court. So that's why sometimes um, when they are going into police, they put money aside. They put money for court cases as well. They make budget for court cases in case this election someone wants to outsmart me, I will go to court. Do you understand? So that's what it means. So and then they go, maybe the court judgment not favor them at the lower level. They go until they get to the Supreme Court, which is the final journey, and then whether it favors them or not, they move from there. So litigation. So it's a formal legal process. Why ADR is what a range constitute a range of what informal processes like mediation, arbitration, negotiation that can be customized by the parties involved. You yourself, you come and define the process, how you are going to come by with this issue. Do you understand? So that's what you do. You yourself do it. You're not going to go to court like when the court you have to look for a jury to come and stand in for you. No, you initiate the process by yourself. Determine what and what should be considered and how you are going to do it. That's what you do. Do you understand? So typically, less structured than litigation. It's less structured. Do you understand? Than litigation. So another aspect area that you can compare this to is time. Time factor. Litigation often is lengthy due to court schedules, procedural requirements, and potential delays. All right, because they ask you to go and look for evidence. You bring evidence, this cross-examination, and do this one and that one. Before you know it, time is going. Do you understand? So cases can take months.